This honorable court is again in session.
Good morning. Welcome to the Utah Court of Appeals. Please be seated. All right, we're here today. But first, I'm Judge Ryan Harris. And with me is Judge Greg Orm and Judge John Luthi. We're happy to be here today to hear your argument in the case of Williamson versus Farrell. It's a case a couple of us are familiar with from a few years back. It's case number 20221084. And let me take appearances for the record from counsel.
Your Honors, good morning. Eric Olson with Christopher Ballard, representing the plaintiffs and appellants, the Williamsons.
Good morning, Mr. Olson. Mr. Ballard.
Good morning, Your Honor. Christine Ellis, along with John Loftus and Mark Gibb, on behalf of appellees Laura Black, Ann Farrell, and David Farrell.
All right, good morning to you all. Thank you for being here. Okay, we've got this set for 15 minutes aside. I know there's a lot to talk about here, so of course if we're asking questions, the clock becomes a non-factor. What I guess I would say is we pay a little bit more attention to the clock here than they do next door, but we're still gonna give you the time you need to help us understand the issues in the case. Any questions before we begin? Looks like 10 minutes on the clock. So have you already communicated about rebuttal time?
That's correct, Your Honor.
All right, then I think we're ready to go, unless anybody has anything for us before we get started. All right, Mr. Olson.
Thank you, Your Honor. May it please the court, Eric Olson and Christopher Ballard for Thomas and Jennifer Williamson. The court should vacate the judgment and fee award and remand for entry of judgment that the Williamsons did not commit financial exploitation, elder abuse. This is because the private right of action that gave the trial court jurisdiction was limited to financial exploitation under the elder abuse statute. In order to have a financial or a legally protectable interest in a declaratory relief action under Weaver, there has to be a private right of action in play. And the private right of action in section 314 of the elder abuse statute is only for acts of exploitation. That's where the plain language of the statute goes. It provides a vulnerable adult who suffers harm or financial loss as a result of exploitation has a private right of action against the perpetrator.
But going into trial, as I understand it, the court actually shaved off the financial issues and left those for the pending probate actions. If there's some financial goings on, I'm not going to concern myself with that. We're looking at what the other side points out, I think rather persuasively, you were characterizing as a rather broad concept of elder abuse and wanted your clients cleared of that. There was no focus at that point, it seems to me, on financial improprieties only.
Yes, there was, and let me just clarify what the trial court did. And as a starting point, I'll just say that the transcript is unfortunately quite terrible of the summary judgment ruling. It is difficult to understand exactly what the trial court
Terrible how?
decided.
Like the transcriptionist made errors?
Yeah, I mean, there's some inaudibility, but there's also a lot of just kind of back and forth discussion without really being clear what exactly is being intended. But one thing that is clear is that what the trial court was deferring or putting off for the probate action was allegations related to the estate planning. The court was not eliminating the concept of financial exploitation for the trial, as shown by the fact that the court ruled on financial exploitation at the trial. And while I don't have the record sites handy, Your Honor, there were allegations that we presented evidence of at trial, accusations leading up to this litigation by the defendants that my clients had stolen money from bank accounts and things like that. So there was a factual predicate for accusations of financial exploitation that absolutely were tried in this case.
Can you talk to me about sort of the way this was framed on your part? I mean, these were your claims, and in your complaint, the claims of the declaratory judgment is that's requested in the complaint is that there was not any form, I think was your word, any form of elder abuse. which is obviously broader than just financial stuff. So when you filed the complaint, you were asking the court for more than this, right?
Yes.
And then at the summary
Yes,
judgment.
I believe so, Your Honor, and, yeah, and I'd like to address that in more detail, but continue with Your Honor's question. I don't mean to
I'm
interrupt you.
glad you conceded that, because I think that's okay. But at summary judgment, then, the way this came up at summary judgment was a little bit hard for me to follow, and I'd like maybe you to walk us through that, so make sure I understand that. It looked like you were raising the issue as a defense to their motion, and saying, look, we're entitled to summary judgment, or they're not entitled to summary judgment because there's no private right of action. But it didn't look like at any point during the summary judgment briefing, anybody ever put this in terms of jurisdiction or justiciability. Nobody ever told the court, hey, look, you don't have power to go any further than this. It doesn't seem to me that the judge ever had it in mind that there was a justiciability or jurisdiction question being raised, in terms of the way that came up. What are your thoughts on that, and can you help me understand that better?
Yeah, so, in the previous, certainly, the complaint when it was filed was very general, it was vague. There's no question about it, going to Your Honor's first question. And we didn't fully flesh out all of the parameters on which there could be a justiciable claim at that point in time. When we got to the judge's dismissal order that led to the prior appeal, there was some commentary in there about Utah versus California that wasn't really dealt with, and we raised this in our reply brief on the prior appeal. The court also assumed that all of the justiciability elements had been met. So we never got into, at that stage of the case, these jurisdictional issues that Your Honor's asking about now. It wasn't until we got back on remand on summary judgment when this started to be fleshed out in the summary judgment briefing. The defendants moved for summary judgment first. They raised the Weaver case in their summary judgment motion. They were the first ones to point this out. And we really hadn't addressed that for the trial court prior to that point in time. And the Weaver case, as was laid out on summary judgment, is jurisdictional. It's a justiciability issue that's presented in Weaver. We then moved for summary judgment, and we made it abundantly clear to the court in our motion for summary judgment that this was a jurisdictional issue, that the limitations imposed by Weaver, or in other words, the need for a private right of action in order to have jurisdiction, justiciability, was something that, in this case, limited the justiciable claims to the private right of action for financial exploitation under the statute. We made that clear. What we also laid out in summary judgment, though, is that there is a possibility of California law applying. And California has a broader statute and a broader private right of action. So we laid out both in our summary judgment briefing. We did make it very clear to the court that it was a justiciability and a jurisdictional requirement. We moved for summary judgment that there was no evidence of financial exploitation, and therefore the defendant's claims should all be dismissed. We should prevail. And I understand that that's awkward where we're filing a declaratory judgment action asking to prove a negative, but as the trial court properly found, the burden of proof in those sorts of situations is on the defendants to prove the substantive claim that's at issue.
Which seems strange, where it's you who's brought a complaint for declaratory judgment. Was there a counterclaim for declaratory judgment the other direction?
No, there was not a counterclaim for declaratory judgment nor for elder abuse in this case. We went forward just based on our declaratory judgment claim. The defendants had filed a competing case in the state of California that.
I guess what's bugging me is there's just kind of a dissonance of you guys filing a complaint saying that you want a declaratory relief, you want a judge to declare that you didn't engage in any form of elder abuse. Then when the judge takes that question on and rules against you, at least in part, you then say, hey, no jurisdiction. Like, there's a second bite at the apple, and there's the loser always regrets the outcome kind of taste here, and I guess I wonder what your response is to that reaction.
Yeah, my response is that had the trial court gotten it right on summary judgment, we wouldn't have had a trial. We wouldn't be here today. The case would have been concluded, with a judgment of no cause of action for the defendants under the financial exploitation statute of the elder abuse statute. That's what should have happened on summary judgment, and that's precisely what we asked for in the summary judgment motion that I filed and argued. It didn't happen. The judge ended up denying it. The judge also determined that he wasn't going to get to California law. He was going to leave all of that for the California case, and he wasn't going to address, as we talked about earlier, estate planning. That was going to be resolved for a probate case. So, assuming all of those things were put aside, what we would have been left with would be a judgment of no cause of action based on the burden of proof being on the defendant on financial exploitation. And that's where we're left today. Had summary judgment been properly dealt with by the trial court, that's what would have happened. And that's what we're asking this court to enter, which is vacating the judgment that was entered and entering a judgment of no cause of action.
Can you give me, maybe this is, Mr. Ballard can help you from over at the table, but can you give a record site where you asked at summary judgment for summary judgment on the non-financial claims on the basis that they were non-justiciable?
I did not ask for summary judgment on the I want to make sure that I'm tracking you. I asked for summary judgment on the financial exploitation claims because that was the only justiciable claim. And then I argued in my summary judgment motion in the alternative that in the event the court gets to these other claims, we had established that there was no genuine dispute of material fact and we were entitled to summary judgment.
On the merits?
In the alternative.
Yeah, but
that was solely in the alternative.
This is where it's making my head that you should have made there, that to make it clear to the trial judges, look, we think the only thing we are trying to put in front of you is the financial exploitation stuff, because that's the only thing we think is justiciable. If you go any further than that, you don't have jurisdiction to do it. We're not asking you to do it. We're the master of our complaint. We're not asking you to go there. And to the extent you do, it's non-justiciable. Instead, you ask for summary judgment on those claims, the non-financial exploitation claims, on their merits. In other words, you briefed, hey, we didn't actually abuse mom, right?
Yeah, but that was only in the alternative. That was in the alternative in the event that my argument that those are non-justiciable was denied on summary judgment. I have the brief here, Your Honor.
Yeah, so
I'll pull that up on rebuttal. I'm glad to address that more. I appreciate Your Honor's confusion on that.
This is kind of the same question,
Yes,
but
Your Honor.
in a different way, and so maybe you can answer it a little differently.
Please.
If you actually do go to trial on the three abuse-based ones, 3012A, B, and C, and neglect, and the financial exploitation, and you go to trial on 5 of those, and then after trial, 4 of them get dismissed, how do we not say that you are not the prevailing party if 4 of your 5 claims that go to trial get dismissed? And you're arguing that we ought to dismiss them, which is the irony. But if we accept your argument and say, yep, 4 of the 5 claims that went to trial ought to now be dismissed, just on that weighing, why are you not the non-prevailing party?
Yes, I follow Your Honor's question. That's a good question, and that's something that would need to be taken into account on remand. We're not here, and to the extent I've been unclear on this in our briefing, Your Honor, I apologize, but we're not asking this court to determine that we were the prevailing party necessarily. We're saying on at least in regard to prevailing party, that the court failed to properly apply the flexible and reasoned approach. What Your Honor just laid out is absolutely something that would need to be taken into account on remand in applying properly the flexible and reasoned approach. Our argument here in regard to prevailing party is that the court shouldn't have gotten there anyway, because that's a bad faith fees element. There's not any other fee clause that would be in place. So the starting point to answer your question would be, if we're successful on appeal and those claims go away, then it shows that this case was not brought in bad faith. But even if we're to go there and we get into the prevailing party analysis, the flexible and reasoned approach would be for the trial court to apply and not for this court to apply. And that would have to be dealt with on remand.
Mr. Olson, in briefing, you don't identify as an issue for appeal in plain terms, the trial court erred in denying our motion for summary judgment. You seem to take on, and not without some persuasiveness, the trial court's disposition following trial. And that, you know, given these findings, this legal analysis is incorrect and so forth. So I'm a little perplexed as to, you're going back to the summary judgment, saying we raised this at summary judgment, we should have won then and there, when that really hasn't been briefed per se.
We've briefed that we should have won then and there, but Your Honor is absolutely correct that we did not frame this appeal as an appeal from the denial of summary judgment. That is correct. We avoided doing that just simply based on the standard of review, since the grounds for denying summary judgment, according to the trial court, were disputed facts. That said, we are talking about a purely legal question here of whether there's jurisdiction.
But we
So-
should look at it the way that the parties have briefed it, through the lens of, here are the findings and conclusions that were entered, and here is the order and the separate order on attorney's fees. That's where we are.
That is correct, Your Honor, that is how we have framed our appeal. That doesn't preclude this court from addressing the fact of the summary judgment ruling. We put a lot of weight on what happened on summary judgment, simply to illustrate, and this goes to Judge Harris's questions just a minute ago, that we absolutely presented this to the trial court, and the trial court had an opportunity to get it right on summary judgment. It just didn't.
Let me ask you one more question about this private right of action issue and the Weaver case. So I get that in Weaver, the court said, look, that these plaintiffs don't have a legally protectable interest in the question, in part because they don't have a private right of action regarding whether a teacher is violating educational statutes.
Public
or
school statutes, right?
something like that.
Right.
But I didn't read Weaver as saying the private right of action question is always, in other words, the be-all, end-all in terms of legally protectable interest. It seems like, I guess my question is it ever possible to have a legally protectable interest even if you don't have a private right of action?
Not that I'm aware of. I will say that the language that we looked at from the Baird case and from the Williams case doesn't define it in terms of a private right of action. It's a little bit different. You know, in Baird, for example, where it's talking about the person not having a right to enforce this constitutional provision. But the concept of Weaver, I can't conceive of any exception to it. I haven't seen an exception to it, and it does appear to be unassailable that in a case for declaratory judgment centered on a statute, there has to be a private right of action under that statute. I can't conceive of an exception to that where the door's been opened under Weaver.
Yeah, let me ask a follow-up question to that. I mean, maybe, you may be right about that. I'm not necessarily contesting that. I'm just thinking out loud and trying to explore this. It seems like there's at least an arguable difference between Weaver and this case, in that the plaintiffs in Weaver weren't actually being accused of anything. Plaintiffs in Weaver, you know, this teacher statute, nobody thought, or even nobody adjacent to the case was saying that the teacher statute applied to them, or that they had any liability under it, or that, you know, they could be accused of violating it. Here, by contrast, your clients had been accused down in California, in court, and in other arenas.
And in Utah court, right?
And in Utah, of committing elder abuse. And it seems like that is at least, it feels different to me. Maybe it's not articulably different, but it feels different to me that you're being actively accused of something that is potentially even defamatory, right, if it's not true, right? It's a big deal to be accused of abusing your mother. You know, it seems like there's an interest in defending yourself against that. That feels different to me than the interest the plaintiffs had in Weaver about whether this teacher was violating educational statutes. And so I guess I wonder, as applied here, whether it necessarily has to follow that you have to have a private right of action in order to say that you have a legally protectable interest for a declaratory judgment action.
'Cause
Thoughts?
they're looking to clear their name, basically.
Right.
I-
Right.
I would, this isn't a question to you, but to join the conversation. If a prosecutor decides not to prosecute, it would be akin to the alleged victim then being able to bring a private right of action to say, I'm not lying that he raped me. Let's go to court and establish that he violated the law to vindicate my allegations.
Right,
Yeah,
right.
the
Is that
distinction,
enough?
the distinction here being is that we did not bring a defamation claim. We did not bring a claim along those lines that is not tethered to a statute. Ultimately, as the case was tried, and we see this from the trial court's findings, the elder abuse issues that were dealt with at trial, each one is just going through different sections of the statute. It was 100% statutory. And so the only distinguishing factor between this case and Weaver is that here, this is a issue of a negative declaratory judgment case, which we dealt with this before in the last appeal. We know that that's proper, that's something that's available. And as the trial court found, in those cases, the burden of proof is on the defendants to prove it up. That's the only distinction between this case and Weaver. The parents and students in Weaver were trying to avail themselves in their deck relief case of claims under this public employee statute. And they had no private right of action. You're correct,
so you
Judge
don't
Harris, that the difference here is that it's flipped and that we are asking a
Well,
negative in how we filed our complaint,
seems
but
like
it still
there's-
doesn't change it.
There's more of a difference, it seems to me, than just the negative flipping. It seems like there's a personal stake here in this. John's example, Judge Luthie's example of the victim wanting a declaratory judgment that despite the prosecutor's failure to prosecute a sexual assault case, I want a declaratory judgment that I was in fact sexually assaulted. What do you make of that hypothetical?
Yeah, but it's still, in our case, it's distinguishable because in our case, it still is tethered to the statute.
Well, okay.
That's
so
how it was left at trial.
In that hypothetical, does the person who alleges sexual assault have the right to bring a declaratory judgment action?
No, because the person would have a private right of action for civil claims of assault or harm, et cetera, but not a criminal claim because there's no private right of action for an individual to go bring claims for, under a criminal statute. Again, unless there's a private right of action, because this actually does involve a criminal statute, and there is a narrow private right of action. So that's the distinction. You can't go, certainly you could go bring civil claims for assault or what have you, but you're not in a position to invoke the statute. That is not a justiciable controversy under Miller v. Weaver, under the Weaver case. So.
While you're up, I mean,
Yeah.
I'd love your thoughts on something about the bad faith statute. The court really seemed to ground its bad faith attorney fees ruling in its perjury finding.
That's right.
And I guess I'd like your thoughts on why you think that's not enough under the bad faith statute. In other words, the court's view of the world is somebody's going to come into my courtroom and lie on the stand, then I think I'm entitled to make a finding that their cause of action was in bad faith if they felt like they needed to support it with perjury. Thoughts?
Yeah, thoughts. I'll give Your Honor two thoughts in response to it. First, in the cases where that has happened, where there has been false testimony, perjury, a lie, however it's characterized, and it's led to judgment under the bad faith fee statute, it was in a situation where the lie, the false testimony, went right to the heart of the legal issue that was before the court. In Valkars v. Fitzgerald, false testimony that the defendant did not damage the irrigation canal when it was the damage to the irrigation canal that was directly at issue, and so on. We've cited these cases in our briefs. This case is different because the lie specified by the court or identified by the court had nothing to do with the elder abuse that the court ended up finding. The lie had to do with the underlying reasons for moving Ruth to Utah. And the court found an inconsistency and false testimony there. But the court found no harm to Ruth from being moved to Utah. The move to Utah did not cause her any harm. There was no elder abuse in moving her to Utah. The elder abuse that the court found was this so-called isolating conduct during the period of time that Ruth was living with the Williamsons in Utah, and
How is the move to Utah not bound up in that? That if you're not moved to Utah, you're not gonna be in the Williamsons' home? How do you divorce the move from the isolation?
Well, it doesn't have to be completely divorced, but I would say that it's tangentially related. It doesn't, there was no false testimony with regard to the abuse, namely isolating Ruth from her family, living with the Williamsons in Utah. That's how I would separate that. It's a tangential thing, as distinguished from those other
The court specifically
cases.
found no isolation of the sort that would trigger the other statute.
I'm sorry, Your Honor, can you say that one more time?
Yes,
I want to make sure I'm tracking you.
the court in its findings specifically found no isolation. Among the four that it found not to
That's
apply,
right.
one was isolation of the sort that's identified in the statute.
That's
Whereas the
right.
gravamen of the court's concern seems to have been her being told to pack an overnight bag and being moved to Utah under false pretenses, basically, and thus triggering the homesickness and loss of association with her church and family and so forth. It's not without an aspect of isolation, but it's not the isolation that can itself be elder abuse under the statute, if I have that right.
Not exactly.
Okay.
The court found no isolation under the statute, and then at the same time, its ground for finding elder abuse is what the court defined as isolating conduct, which is a made-up term that's not in the statute, and is, in our view, tantamount to isolation, yet that was the ground for elder abuse, is this so-called isolating conduct, according to the court's findings. So no, that is the conduct on which the court found elder abuse. The
Well,
court came right out and said there was no harm. I cannot find any harm from the move, the relocation of Ruth from California to Utah. That actually was an affirmative finding.
That, what you're telling me seems inconsistent with conclusion one on page 26 of the court's ruling. Plaintiffs committed elder abuse under Utah Code 3012A. The court finds and concludes that Ruth did suffer harm within the meaning of the statute. Specifically, she suffered emotional distress, hurt, and suffering. Ruth also suffered harm while living in Utah with Thomas and Jennifer. This harm was caused by being moved to Utah under the circumstances by which she was moved here and being effectively cut off from the rest of her family and the life she was used to.
Yeah, but then the court goes on to say that I find no harm from her move to Utah. The harm, as the court gets into it, is the homesickness, et cetera, while living with the Williamsons. So anyway, there's a tangential connection. Certainly, it's not, to use Judge Luthie's term, completely divorced.
In fact, in some ways, it seems like the hinge point, that if the reason for bringing mom to Utah and bringing mom to Utah is what led to this litigation. And if we're lying about that root or the hinge point or where this all stemmed from, however you want to say it, it seems like the court's finding of perjury went to the whole impetus for the lawsuit, and that ought to make a difference.
I think that's the justification that the trial court gave, but I disagree with that, and the additional reason, going back to Judge Harris's question a moment ago, if I can just finish that up, which I think answers Your Honor's question, Judge Luthie, is in order to conclude that the action is meritless and therefore fees are to be awarded under the bad faith fee statute, the court has to conclude that the entire action was meritless. And that means meritless, patently groundless. The action, not just the claim, but the entire action has to be patently groundless. But as the trial court concluded, as it explained in announcing its ruling, this was a close issue. It was struggling with its decision even on the way to the court that day. Where we have a case with at least 4 of the 5 claims having gone in my client's favor, it was error for the trial court to say that the entire action was patently groundless. And while, going back to Your Honor's question, Judge Luthie, while the court did try to say that he tried to address this issue by saying the move to Utah somehow was the whole impetus for filing this lawsuit, that simply is not supported by the evidence. We have several different claims, and 4 of those 5 claims went in my client's favor, showing that the case was not patently groundless.
Unless we reverse on your argument and they all 4 get dismissed.
That is correct. That's absolutely correct. If this court reverses, then
Those 4 claims do not go in your favor.
then those 4 claims end up going away. And yes, to the extent we brought claims centered on those statutes, then that would not go in our favor. I think that's correct.
And with respect to those 4 claims, you don't have private rights of action on those either, right?
That is correct. Well, the 4, let's be clear. The 4 we prevailed on include the financial exploitation. So the one we did not prevail on, there's no private right of action. 3 of the 4 we did prevail on, there's no private right of action. Sorry if I didn't make that very
Okay.
clear.
My math was off.
No. No, you're fine. Unless there are other questions, I'll save what little time I have for rebuttal.
No, you'll get your full time
Thank
that
you,
you
Your Honor.
reserved on rebuttal. We had a number of questions, as I thought we might, so thank you, Mr. Olson. Ms. Ellis?
Good morning, Your Honors. May it please the court. My name is Christine Ellis, and I represent appellees Laura Black, Ann Farrell, and David Farrell. This court should affirm the district court's declaratory judgment and order awarding attorney fees, which it issued following a 3-day bench trial for 3 reasons. First, the district court's mandate to make its findings was expressly confirmed by this court in Williamson V, and no, quote, jurisdictional defects exist to divest the district court of the ability to make such a determination. Second, the district court's findings as to, quote, harm within the meaning of section 62A, 30117 were supported by the weight of the evidence presented at trial and credibility determinations reached by the district court. And third, an award of attorney's fees pursuant to the bad faith statute was appropriate here, in large part because the district court found both appellants to have perjured themselves during trial.
So on that point, let me just start there with some questions. I get why somebody who perjures themselves in front of a court could lead a court to conclude that they brought the case in bad faith. But there's 2 elements that you needed to show in order to win, well, actually 3. You got to be at the prevailing party, first of all. But then assuming you're past that element, you've got to show that the claims were without merit, which means they're, I think the case law says, fairly close to frivolous. And you've got to show that they were brought in bad faith. The without merit prong goes to the quality of the case, sort of in the abstract, and the bad faith prong goes to the motivation for bringing it. So back to my question, I think the perjury can definitely go to the second part of that. Your motivation for bringing it could definitely be impugned if you think you need to get up on the stand and lie. But how does that help inform the without merit question? It seems like here, they had a lot going for them in terms of the merit of their claim. The court itself even said it was a close call. How can we say that the quality of the case they brought was somewhere close to frivolous to the point where it could be determined to be without merit under the bad faith statute?
So yes, Judge Harris, I think actually the court flipped it. I think what the district court did was it relied on the perjury finding to find a lack of merit. And then it independently analyzed the second prong of bad faith and found the first and third prongs were present. And I think what Valcarce and subsequent cases like Topic versus Thurber tell us is that it is absolutely appropriate for a district court to reach a finding on the lack of merit prong based solely on false testimony. because false testimony is not a legitimate mode of defense, and that's what the Valcarce case tells us. So Judge Quorum, as he wrestled with the,
Okay, so in a case where somebody lies on the stand, that's just it? We don't look at the rest of the case? Like they lied about X, but they've got a stack of evidence this high supporting their case otherwise. Just because they lied about X means that the rest of the case was without merit, and we don't look at the rest of the evidence they might have in their corner?
so, Your Honor, the standard is that the lie has to be directly related to liability. And here we think it is, and I'll address that in a moment. But to get to your point on the stack of evidence, I have two responses to that. One is, it is not correct to say that the district court found only a lie with respect to one discrete aspect of the case. In fact, reading directly from the district court's findings, what the court found was, I found essentially all of their testimony to be incredible and not believable. Certainly, there were some aspects that were supported by uncontroverted documentary evidence. But outside of those kinds of things, frankly, I would presume everything the Williamson said was false as it relates to the facts and circumstances of this case. And I'll also point out that in the Valcarce case, the case that sets the standard for allowing courts to rely solely on false testimony, the court there did not say that there was no countervailing evidence. The court said that it analyzed some of the evidence, and while it had some evidence that would support its claims, it looked at the lie and said, we'll look at just one lie by example that is illustrative of what we believe to be the false testimony. But the court in Valcarce did acknowledge that there was other testimony and evidence that could have supported the party's claims there, that was found to have lied in support of an award of attorney fees under the bad faith statute. So in response to your question, Judge Harris, I think that if there is some evidence that you could stack up and say, hey, our claim was meritorious, that doesn't necessarily override a finding that if your sole mode of defense is based on offering perjured testimony to the court, which is essentially what the district court found here, then the first prong of a bad faith analysis is satisfied. And that's what Judge Quorum found, and it is true that in his oral ruling, he did say it was a close call, and he was struggling with some of the legal issues. In particular, he was struggling with what isolation means under the statute, in the absence of any case law to give him guidance as to what isolation means. He made a conservative call and said, I will only rule that there's isolation if there's complete isolation. Essentially, if somebody's locked away and completely prevented from having any contact with the outside world. That's isolation. And that's what he said was a close call. He also said knowing versus intentionality as a mens rea standard for the harm prong was a close call. But those were comments that he made in his oral ruling. By the time he rendered his written ruling, it was decisive. There is no equivocation. And the fact that both appellants offered perjured testimony was the underpinning of his finding on merit. On bad faith, he found that appellants lacked an honest belief in the propriety of the action that they brought. And yes, in part that's based on the lies, it's based on knowledge. But you can't completely separate those two things. Because if you come to court full well knowing that the claim that you're prosecuting has no grounding in law or fact, or at least has no grounding in fact, because you know that you brought your mother here under false pretenses for the purposes of exerting undue influence over her estate plan.
Yeah, I guess I just don't see that it follows that just because you're going to come to court and lie about bringing your mother here about false pretenses, under false pretenses, that it follows from that your claim has no basis in fact. It seems like those two things are not necessarily linked. And in this case, they had a bunch of other evidence. They had medical evidence, they had doctor's reports, they had evidence that mother had her own attorney and her own guardian and all these safeguards that they put in place to make sure she was well taken care of. And looking at all of that, you're saying, well, it doesn't matter. They came to court knowing that they were going to lie about the reason they brought her here, so we don't need to look at that, basically.
I think that's what Valcarce tells us, and that's for the merit prong. Yes, lying alone is enough if it's connected directly to the liability. On bad faith, the first prong directly tells us you have to look at the honest belief in the propriety of the actions. So that's why the court has to delve into issues of subjective intent, which is why it's a factually intensive inquiry that's afforded great discretion at this level. And I'll also point out one logical problem perhaps contradiction raised by appellant's argument. If it's correct that there's no private right of action and that there was no justiciability over the physical components of the elder abuse claim, the 4 out of the 5 as they call it, even though we contend there was a single claim, if it is true that there was no justiciability, well, then the case had no basis in law, which would also satisfy the first factor. There was no basis in law for most of plaintiff's claims, appellant's claims here, because they weren't justiciable. So it's hard for them to have it both ways here. If your honors will allow me, I'll move to the first issue on the private right of action, unless there are more questions on attorney's fees.
I have one question. The Kelly versus Timberlake's opinion, we affirmed an award of attorney's fees on the bad faith statute, but not across the board. From the point in time when the plaintiff proceeded to trial with false testimony. So I think our cutoff was from and after the denial of the motion for summary judgment, you went to trial on the strength of a forged document, basically, in that case. And I'm wondering if here there isn't a similar analysis that should come into play. You know, they brought the complaint for declaratory judgment, lost once, came up on appeal, won there, went back down, and yeah, when they got to trial, according to Judge Coram, used knowingly false across the board. The plaintiff's defendants were not truthful in their testimony. So even though the action, in a sense, like in Kelly, the action itself wasn't brought in bad faith, proceeding post-summary judgment to trial in reliance on a perjured testimony, that's bad faith. Why should not the bad faith attorneys be limited to that last phase of this matter?
Because, Judge Orem, we would say those same defects were present at the incipient of this case. And this also overlaps with the arguments on private right of action. If you look at the complaint in this action, it's only 4 pages long. It sounds totally and utterly in physical elder abuse. There are no allegations that would give rise to a theory of financial exploitation.
Well, that's overstated, right? They said any form of elder abuse.
They do, but the examples they give are, for example, reading from paragraph 14 of the complaint. After Ruth Williamson moved to Utah, Black and the Farrells began accusing the Williamsons of committing elder abuse and of breaching various other statutory and common law duties. As Ruth Williamson's health worsened, the accusations became more frequent. After Ruth Williamson passed away, Black and the Farrells continued to accuse the Williamsons of abusing Ruth Williamson and even implied that the Williamsons' actions had resulted in Ruth Williamson's death. Paragraph 18 talks about in regard to their care for Ruth Williamson. That same language is used in paragraph 20. Paragraph 21 refers to the medical professionals who could witness the interactions in the level of care. Paragraph 22 again says, Williamsons provided the utmost care and attention to Ruth Williamson to ensure that her needs were taken care of. So yes, the language is broad enough that you can later come to the district court and say, no, we meant to include financial exploitation. But if you're a defendant who's been hailed into court and wondering what it is you have to defend against, and you read the complaint, you believe the accusations have to do with physical elder abuse. More importantly, what happened at trial is we had this protracted debate over burden of proof, justiciability, that went all the way through trial. And by the time we got to trial, the lay of the land was plaintiffs, appellants bore the burden of proof to establish justiciability. And the understanding was they would have to do that by showing that accusations were made. If they met that standard, the burden would shift to defendants, appellees, to essentially prove their quote-unquote claims of elder abuse. The accusations that were presented in plaintiff's case in chief went entirely to this notion of kidnapping in the colloquial sense. That the appellees believed that appellants had kidnapped Ruth Williamson and taken her to Utah. And so to answer your question in a roundabout way, Judge Orm, If the entire theory of the case was we're going to clear our names of kidnapping and prove that we didn't bring Ruth Williamson here under false pretenses, and the only way to make that showing was to lie to the court, then the bad faith standard set forth and articulated in Kelly versus Timberlakes is satisfied here, and it's on all fours with that ruling. As are other rulings that say where a party challenging attorney's fees comes forward and tries to say, well, it wasn't a complete win. For example, in the Gallegos case, they wanted punitive damages. They didn't get it. Or we were able to reduce the amount of compensatory damages that were awarded. And looking at what was actually presented to the court has not, again, the idea that you would have a complete win and overcome every single theory is not the standard. If you prosecute your claim or your defense in bad faith and on perjured testimony, then the two prongs are met.
May I ask a question about private right of action?
Yes, please.
Is it your contention that there is a private right of action for the kind of abuse that the court found did happen here?
We contend that you can read the statute, that the statute can be read under the the rule of statutory interpretation of rule of the last antecedent, to read it that way, meaning it's harm or financial loss as a result of exploitation.
Do you read it that way?
How-
You say it could be read that way. Are you taking the position that there is a private right of action?
Yes, Your Honor, but we're also taking the position that it doesn't matter. And the reason it doesn't matter is because it's an overstatement of the law to suggest that there is a requirement within Utah statutory and common law that in order to prevail on a declaratory judgment action, that the plaintiff must satisfy a showing that there is a private right of action.
So I'd come to my analogy before to the criminal law. I think I should have said it more, what would be more parallel here is someone's accused of an assault and the prosecutor decides not to charge for whatever reason, but they want to clear their name. Do they have a private right of action for a declaratory judgment that they did not violate the criminal code?
I think they would, Your Honor, and I think it would depend on whether or not the facts and circumstances, is the accused assailant out there saying that his name was cleared and that he didn't do anything wrong. I think that there are other facts that would give rise to informing the analysis of whether or not there is a clash of legal rights, whether under the broader language of the Declaratory Judgment Act, whether we can get to the parties' rights, legal status, determination of those things. Rights, status, or legal relations is the language used in the Declaratory Judgment Act. So I think that, yes, a victim in that case would have an ability to seek a declaratory judgment action.
Well,
More-
in his hypothetical, it's not the victim, it's the person being accused.
I changed my hypothetical.
Oh, I'm sorry, I
Yeah,
missed
but
that.
yeah,
Which he
the
thinks
accused.
is more analogous to what's going on here, and I think that's probably right. So changed hypothetical, do you think there's a private right of, do you think there's a ability for somebody who's accused of, say, an assault or a sexual assault or whatever crime you want to come up with? But the prosecutor's not going to bring the criminal charges, so we're not going to have a criminal case on this. Can the person who stands accused bring a declaratory judgment action in court to clear their name?
And not against the state, but against the victim
Accuser.
who's alleging it,
The accuser.
the accuser.
I think that also depends on whether or not there is an ability in Utah to bring a civil, whether the victim would have had a civil, parallel civil action. Because again, justiciability isn't limited to private right of action. What the courts are required to do is to look at whether or not they're being asked to render an advisory opinion, whether or not there are any actual rights at issue. And so if,
And wouldn't that be exactly the case in that hypothetical, that the accuser is not bringing a private action, but is just out there saying, I've been assaulted, and now I want to bring the declaratory judgment to clear my name. And I guess I may have just answered my question. If the accuser had a civil cause of action, then there could be a declaratory judgment action probably to declare that, no, you don't, that civil cause of action isn't good. Here, there is no cause of action. The argument is and I know you're making another argument, the argument is there is no private right of action. I guess, can you come up with an example where there is no private right of action and the court has said that is not an advisory opinion for us to just answer whether, in this case, the elder abuse occurred?
Yes, Your Honor, there's lots of examples. I think in the example, the hypothetical that you gave just now regarding whether the person who stood accused would have a private right of action. If there's no civil action for the victim to bring, then I think there isn't one, because I think then you're just, again, in the general advisory opinion land. But in the, to answer your question, to answer more directly your question, there are lots of those situations. What Miller versus Weaver says, it's a case that's limited to its facts and the posture of who's the plaintiff and who's the defendant. What Miller versus Weaver said, and what counsel for appellants reiterated, is that is the rule. The private right of action is the rule when a party is challenging a statute, enforceability of a statute or a constitutional provision. That's what we had in Miller versus Weaver. That's what we had in Baird. That's what we have in any number of cases, the Lyon versus Bateman case, where the person bringing the claim, a taxpayer, somebody similar, is challenging a statute. If you look at the complaint here, there's no reference to a statute at all. It is not at all clear from the complaint or from the subsequent history, even up to summary judgment, that the question that was being presented to the district court was limited to the enforceability of a specific statute under Utah law. So Miller versus Weaver doesn't even apply for that reason. It also doesn't apply because of the plaintiff versus defendant reason and the accused versus party being accused. And in response to the hypothetical you gave, Judge Luthi, there are also civil claims for defamation, which is something that we had raised below as well. If you believe that your name is being muddied, if you believe that you are being falsely accused of something, then there is a civil claim for defamation that the plaintiffs could have brought here. But what Miller versus Weaver tells us is the plaintiffs, not the defendants, the plaintiffs can't use the declaratory judgment device in lieu of a private action or a direct claim. But what it doesn't say is the threshold gating question that every district court should apply when it receives a complaint for declaratory judgment is whether or not the plaintiff bringing the claim, has standing to bring the claim, whether it could meet all the statutory elements. And on that, I would submit to your honors that even if you were to adopt appellant's view of the world, their requested relief of remand would be inappropriate. You could not simply remand to the district court and say, enter a finding in their favor on financial exploitation, because we would then have to, if they are correct, analyze the financial exploitation cause of action through the private right of action lens. Counsel for appellants referenced an argument we made on summary judgment with respect to Weaver, and that was the argument, not this one about a private right of action on financial exploitation, the way they're framing it now. The argument is, well, the private right of action goes to the personal representative if the vulnerable adult has passed away. And here, none of the appellees had ever sought to be appointed personal representative. The only party who sought to be appointed personal representative was Thomas Williamson, one of the appellants. So there is no private right of action for any of the appellees here to bring that financial exploitation claim. Moreover, the statute of limitations on such a claim is 3 years. Ruth Williamson passed away in November of 2016.
You're kind of losing me on what your basic position in the case is. Did Judge Coram have jurisdiction over the non-financial exploitation claims involved in this case, or didn't he?
Yes, he absolutely did.
Why?
Because as this court ruled in Williamson 1, and by the time he got to trial, the accusations and the allegations set forth by appellants provided a justiciable controversy. There was a real controversy among the parties as to whether or not appellants had abused their mother by the act of transporting her to Utah and during the months that she lived here prior to her death.
And you were working off of the definition of abuse in the statute as you went to trial?
By the time of trial, once there was clarification provided by appellants as to what relief they sought, and once Judge Coram ruled that California law would not apply, we only found out that we had the burden of proof in 6 weeks before trial. as a result of that summary judgment ruling and the court's finding on burden of proof in Medtronic. And when faced with how do we go about proving that elder abuse did occur here under Utah law, we looked to the statute. But the complaint didn't point us there.
All right, but once you find out that this is at root a statutory claim that's going to turn on the statutory definition of abuse, at that point, does the court have a jurisdiction, or is it justiciable? Because there's no private right of action under that statute for anything other than financial exploitation, arguably.
Yes, Your Honor, I think this is what the court was wrestling with based on the finding in Williamson 1, which is you don't need to look to a statute. There are allegations of abuse, and there's a desire to have their name cleared. So the district court felt that it had a mandate to reach that determination.
Okay, if that's true, if it's as simple as that, then why doesn't the person being accused in Judge Luthie's hypothetical have grounds to come in for a declaratory judgment? I thought your position was, in that hypothetical, the person being accused wouldn't have the ability to come in and seek declaratory relief to clear his name. Did I misunderstand your position?
No, you didn't, Judge Harris, but I think Judge Luthie's hypothetical contemplated, at least as I understood it, an accrued set of facts at the time of filing the complaint that we don't have here. We didn't have that accrued set of facts by the time of the filing of the complaint, that all we were going to ever be looking at was this very specific issue.
Okay, but once you have those accrued facts, which apparently was 6 weeks before trial, how is this case different than the hypothetical? I mean, how your positions don't seem to line up to me.
Because the appellants here were still saying that there was a legal right that was in the air for them. And one other thing I'll point out in regards to the private right of action is this notion of there are things that the Adult Protective Services Department can investigate and enforce, and then there are things that are left to the private right of action. The allegations in the complaint and forming part of the basis of appellants showing that there were accusations that were made was a referral, a complaint made by appellees to APS while Ruth Williamson was alive. So you could imagine in that situation, unlike Judge Luthie's hypothetical, where the district attorney's office has said we're not prosecuting, you could imagine in this hypothetical, APS is still considering whether or not it might enforce something, whether it might investigate something.
But then wouldn't your declaratory judgment action ought to be against the agency who has the ability to enforce the statute and not against the victim, so to speak, who has no enforcement authority of the statute?
Again, if that were an action that specifically said on all four, within the four corners, that they were challenging a specific statute and saying,
And I
we
guess-
want to know.
Yeah, I guess I don't see very much breathing room between the constitutionality of a statute and the applicability of a statute. That if what we're trying to challenge is the statute, whether it applies or whether it can apply because it's not constitutional, that if you're not the one that can enforce the statute, then you can't bring a declaratory judgment against that person. Why should we treat constitutionality of here's the question, why should we treat the constitutionality of a statute different from the applicability of a statute?
You shouldn't, Your Honor, and that is again, going back to plaintiffs being the masters of their complaint and what relief they sought. And had they sought a determination that APS could have no investigation here, that claim would have properly been brought against the APS. What we're analyzing here is how appellees, when they had the burden of proof, chose to make their showing that elder abuse, writ large, had been committed here. And with no guidance, the appellees, and with the court's, I think, tacit approval, looked to the statute to say, well, we have to make a showing. We have to go through elements so that the court can feel comfortable that there was elder abuse that was committed here within the meaning of the statute. But that's different than a complainant coming to court and saying, we want answers on this statute specifically. That would raise questions, absolutely, Judge Luthie, as to who is the right defendant. And it would also raise a host of other issues, such as the private right of action issue raised in Miller versus Weaver. But that's not the case we have here. And the fact that by the time we got to trial, we looked to the statute to put on our case doesn't change that essential predicate that we're not even in Miller versus Weaver. And if you were to adopt the appellant's reading of that statute, the court would essentially be creating a new regime for declaratory judgments that would be much more narrow, that would place this gating requirement on district courts to say, let's look at the direct claim. First of all, you have to have a direct claim that's issued. You can't just have a case or controversy, which is not what years and years and years of case law in this state have told us. They have, in fact, said the opposite, which is you don't need to have a specific case or controversy, but you have to show us that you have some clash of legal rights, that there's something that would be resolved by us ruling. And appellant's reading says, no, you have to have a direct claim. And not,
What was resolved here by the district court making a finding of elder abuse under 3012A? What was resolved legally?
what was resolved was the question of whether, open question prior to trial, of whether or not appellants committed elder abuse against Ruth Williamson under Utah law within the state of Utah while Ruth Williamson was here.
The trouble is that doesn't seem to matter anywhere legally, because if the agency were to still come in and do an enforcement action, there's no res judicata against the agency based on that finding, because they weren't part of this declaratory judgment action. So it seems like we still don't have any meaningful resolution of a legal right.
Well, as Judge Orm pointed out in his concurrence on Williamson 1, there would be deference by the California court to any findings on Utah law. So to the extent that whether or not elder abuse was committed against Ruth Williamson while she lived in Utah, to the extent that comes up in California.
Which might have mattered if everybody had agreed to litigate the California law issues here, but nobody did. So how does it matter to the California court whether there was a violation of Utah law?
Well, to the extent the California court takes a similar view, we don't know yet. We don't have we're not that far along there. But to the extent the California court says, well, that's well and good that you have these theories of elder abuse that occurred in California. But as to what happened to Ms. Williamson between March and November of 2016, we can't reach those questions because she was in Utah at that time. They could look to this ruling. There was the pending probate action in which gave rise purportedly to this entire lawsuit about where the accusations came from, where the objection to Thomas's request to be appointed personal representative, the objection was made on the basis, in part, that he committed elder abuse against Ruth Williamson. And that was part of the tension between the first filed action and what was within the jurisdiction of the district court here and what was without his jurisdiction based on the first filed principle.
I'd like to ask a question to Mr. Olson based on something you said earlier, so I want to make sure that I understand what you said earlier. That if we were to agree that, I want to get my phrasing right, get the right. That this turns on whether there's a private right of action. And that because your clients did not have a private right of action, that the court lacked jurisdiction. It seems like you made an assertion that even the financial exploitation finding, your clients did not have a private right of action because none of them were the representatives of the estate. Is that the argument that you made?
Yes, that's the statement that I made. I don't know that I would phrase it as an argument. The point of that statement is to point out the untenability of the argument that's being presented here. But yes, that is correct, and that was an argument we adopted below
Because it seems like if you're correct on that if we say you have to have a private right of action for there to be a justiciable controversy and move forward in declaratory judgment, then if we rule on that issue in their favor, then maybe all of their claims go away, including the one on financial exploitation. Is that correct?
That's right, Your Honor. And there are other reasons why the financial exploitation ruling could not stand on its own. But again, to make that request and for remand to the trial court would be, again, to say, you can look at whether there's a private right of action. But we want you to put blinders on and only look at whether there's a private right of action in the statute. But don't look at anything else. Don't look at whether they satisfy, whether they have standing, which they don't here. And a case that was heavily relied on by appellants for the private right of action, in addition to Weaver's the only case that they can point to say that there's this broad rule, which we argue is not a broad rule, is the Kane case, which is a standing case. It's not a declaratory judgment justiciability case. It's a standing case. So would the district court have to look at standing? Would it have to look at mootness? Would it have to look at other affirmative defenses that could have been raised? I don't think that's the framework that we want to put onto district courts when the standing law right now in Utah is that the judicial power to issue declaratory judgments is broad and not constitutionally restricted to cases and controversies. If there are no other questions, my time has long expired.
Okay, thank you, Ms. Ellis.
Thank you very much, Your Honor.
Mr. Olson, rebuttal.
Thank you, Your Honor. There have been a lot of great questions. I don't know that I'm going to be able to answer all of them. I'll try to cover as much as I possibly
I
can.
want you to answer this
Can I
one.
start with your question that you already asked?
Yeah,
Okay, your question is a good one. Under California statute, it can be any representative, any interested family member who can bring the private right of action under their elder abuse statute. Under Utah, it is more limited.
but you went to trial under the Utah law, right?
Ultimately, we did because the court decided not to apply
And
California
so
law.
it
But
seems
this
like
issue
you're-
was not raised below,
You're right, but this goes to
it is a
jurisdiction.
jurisdictional issue.
Right. And so if your argument is these defendants don't
Right.
have a private right of action,
Yeah.
and so these claims should be dismissed, why is that not true as to the financial exploitation claim?
I think Your Honor's correct.
So all of
because-
your claims get dismissed?
Jurisdiction is jurisdiction. It's not something we can create.
So here's what the dominoes seem to me to be, that you filed a complaint, litigate for years, and at the end of the day, none of your claims were justiciable, and your clients lied along the way.
That's not true.
So,
And-
yeah,
and
where
here's my response
are
to
we
that.
wrong on that?
Yeah, so here's my
Summary.
response to that. The only additional angle I would add to that is that we also asserted that claims could be decided under California law. And we addressed that in our summary judgment motion. We went through the California statute, and we explained how if California law were to apply, this is how the court should go down on the California law issues.
But you're not.
Those were not adjudicated on the merits, we're
but
not
you-
appealing
you're
from
not-
that
You're
as
not
well.
appealing that
I
decision.
assume that was gonna be your honest
Yes.
question. We did not appeal from that determination, but it was not a ruling on the merits. And I think your honor's question went to effectively a ruling on the merits. It just simply was not adjudicated. But I agree with all of your honor's comments regarding jurisdiction. They're correct. This issue was not raised, but it's jurisdiction.
Mr. Olson, I want to
Yes, Your
ask you a question, because I struggle with declaratory judgment jurisdiction being tied so completely to the existence of a private right of action. And I think the point is well made that Williams I confirms we've got a judiciable controversy here. No discussion that I recall in that opinion or argument leading up to that opinion.
Agreed.
That there was no private right of action.
Agreed.
And I think of a situation like this. The Utah legislature passes a law that makes it illegal for any seller of apples in Utah to sell apples to someone from out of state. And the statute concludes with, there shall be no private right of action under this legislation. It strikes me that a Utah apple grower could bring a declaratory judgment action to have that statute declared unconstitutional as infringing on the Commerce Clause. And I can't imagine that we would say, well, as interesting as that might be, you got no private right of action, so you're just gonna have to live with it.
There's a difference in my mind, Your Honor, and I haven't researched this angle of your question. It's a good question. There's a difference in my mind between someone who's challenging the validity of a statute or a constitutional provision and someone who's trying to enforce rights under it. And that's what we're dealing with here. We're not dealing with either side trying to attack and unwind on any ground a statute. I can see some merit to Your Honor's hypothetical. That's interesting.
I think there's a lot of merit to that
Yeah.
hypothetical
Yeah.
if the defendant in the declaratory judgment action is the agency charged with enforcing that law.
I would agree with that as well.
But if you bring the
Yes.
declaratory judgment action against your competitor apple seller, that you'd say, wait a minute.
That's the
that
distinction.
competitor would have to have a private right of action against you to make sure that they could sue you to not be selling out-of-state apples. And that's what we have here, is you've brought a declaratory judgment action, not against the agency that can enforce the elder abuse, but about the siblings that are complaining about it.
I agree, and that goes to Your Honor's comment just a minute ago, or your question about what is resolved by the elder abuse judgment other than on financial exploitation. And the answer is absolutely nothing. Nothing stops APS from coming in and investigating, finding, charging, enforcing elder abuse in this case. It's not res judicata. They weren't involved in the underlying proceedings. And that goes to the need for a private right of action and demonstrates that what we have from the trial court is merely an advisory opinion. And as we've discussed now, it may be an advisory opinion on everything.
So it seems like you've conceded that all of your causes of action were non-justiciable, that we ought to reverse on that ground and remand the case for the trial court to decide who was the prevailing party.
I don't
And
concede
all
that
of you.
because I don't concede that to the extent claims could be governed by California law, they would be justiciable. But at the same time, we haven't appealed from that ruling, but that still would prevent me from conceding what Your Honor just asked. Very, very quickly, I need to come back to Judge Harris's question because you asked me a question earlier, and I just wanted to cite for Your Honor, before I sit down, the relevant provisions of the summary judgment briefing where we addressed these questions of there needing to be a private right of action. I could refer you to the entirety of the briefs. I'll try to reference very quickly just some of the specific arguments that I made. The motion for summary judgment starts on record 2270.
Is this your motion?
Yes, this is my motion.
Okay.
And the reply started on record 3238. And I also want to add.
What was the first reference? I
I'm
wrote down
sorry.
270 in that. I may
I'm
be
sorry,
missing
Judge
it.
Orm, let me find that. It's 2270 was the motion, and 3238 was the reply. And for the record, the defendants also raised Weaver and contended that there was no legally protectable interest without a private right of action on record 1417. That's not the first page of their motion, but that's the page of the defendant's summary judgment motion
The
where they
page
took the
again, I'm
exact
sorry.
same position. That was 1417 of the record. Both
Where
sides agreed.
defendants raised Weaver.
Yes.
You say-
Yes, both sides raised Weaver. Defendants raised it first. And they contended that you had to have a private right of action for there to be justiciability. They argued against justiciability. We then cited Weaver, and we explained in our summary judgment motion, sorry, that's a reply. We explained in our motion, this is on page 18 of our motion, which is record 2288. We explained, we walked through exploitation, we walked through the statute, we explained that sexual exploitation is not in question, personal dignity exploitation is not in question, and so all that's left is financial exploitation. I wrote, what remains actionable here is financial exploitation, but as shown below, this claim fails as a matter of law because there is no evidence of any harm or financial loss to Ruth with regard to each of the alleged acts of financial exploitation detailed in defendant's motion. And then I went through and addressed that in regard to Jennifer. I addressed it in regard to the estate plan, Thomas's management of the 101 trust estate, and so on. I don't need to go too much further on that, but I went into great detail in the motion about how that is all that is left in the case. In the reply on page 20, which is record 3260, I explained that the defendants do not refute that their private right of action under Utah's elder abuse statute is narrow and can extend only to financial exploitation. which involves a deprivation of funds, et cetera. And I go on to say that after all briefing, defendants have failed to come forward with any evidence of financial exploitation of Ruth. Summary judgment must be entered as a result. So my argument below was that this case should be ended on summary judgment with an adjudication of the financial exploitation claim, and that was it. That was
Under-
all
under
that was
California
properly
law.
before the court, unless, as it goes on to say, the court decides to apply California law. And in regard to California law and summary judgment, I presented an entire argument.
But the court didn't apply California.
He did not apply California law ultimately. Well, he denied the whole motion and then stated, based on Judge Orm's concurring opinion, that his role was to address simply Utah law. But I laid out everything under California law. The other side did not oppose it, but ultimately the court found fact disputes and decided not to apply California law. So I apologize, Judge Harris, that was a long-winded response to your question, but I just wanted to make sure you had those record citations.
Thank you.
So just to wrap up, we would ask the court to vacate the judgment below, and especially the attorney fees award, particularly where the attorney fees award conflates the lack of merit prong and the bad faith prong. Lack of merit means utterly meritless, and that simply was not shown and was not dealt with below by the court. Thank you, Your Honors. Appreciate your time today.
Thank you, Mr. Olson. Thank you, Ms. Ellis. We appreciate the arguments made. A lot of stuff to go over here. We'll take this matter under advisement and get you an opinion as soon as we're reasonably able to do so. Thanks for coming in today. Court's in recess.
Thank you, Your Honors.
All rise.